The Supreme Court, viewers, seems to be exasperated with the government on the issue of judicial appointments in our country. Now, usually how it works is, for judges, the Collegium from the judiciary sends its recommendations for appointments to the High Courts and to the Supreme Court. They send their list of recommendations after internally discussing amongst them, and then the government takes it up. And then the government looks into those recommendations and gives its approval or not. Sometimes if the government is not convinced with the certain name, then they send it back to the Collegium. And then they reconsider. They can either change and give another name, or they can, if they feel that this judge does deserve to be appointed, they can reiterate. Now, in this back and forth that has been going on, what has happened is significant delays in the appointment. 6 times this year already, the Supreme Court has made some very, very scathing comments about it. For example, on August 9th, the Supreme Court said, you don't make appointment after Collegium recommends it. That's what they told the government. We gave you time-bound directions to appoint judges. The line has been crossed by the government. You cannot let the third pillar of the democracy, which is judiciary, come to a standstill. 3 days prior to this hearing, Chief Justice of India asked the government if it wants all tribunals wrapped up, because the tribunals were facing massive shortage of manpower. So an exasperated Chief Justice said, do you just want to wrap these up? Few months before that, in April, Supreme Court said High Courts are in a crisis situation. Many High Courts have under 50% of sanction strength. Under 50% of sanction strength. Only less than 50% of judges are actually there than the posts that were created in many of our High Courts. 18 weeks time limit set to process names. 18 weeks. It's not even that the time frame is very small. Before that, a month before this, the then Chief Justice, S.A. Bobde, part of a bench, pulled up the center saying 55 names are pending with the government for more than 6 months. And this has gone beyond any degree of reasonable period. A month before that, Supreme Court said once Collegium reiterates the names, the government cannot then hold back. Why are you keeping these recommendations pending? A month before that, Supreme Court said if you don't give comments for 5 months on recommendations, it is a matter of great concern. Now, you can turn around and say, Tanvi, how does it matter to us? The government and the court are fighting. The court has a certain view on who has to be appointed. Why should they have all the power? So they send it to the government. The government needs to do its due diligence and decide. Let them fight it out. How does it matter to us? That may be a relevant point to make, but I'll tell you how it does matter to you and why you should be concerned about it. Because if there aren't enough judges in our tribunals, in our High Courts, in our Supreme Courts, the cases begin to pile up more and more and more. Justice gets delayed. Cases go on for 1 year, 5 years, 10 years. Judges are overburdened. So you come back to the position where, frustrated and exasperated with the system, somebody comes and comments and says, Tariq pe Tariq. Why does it happen? It happens because our system is overburdened. Should it happen? Can this be fixed? It can be fixed if you fill up these posts to begin with. You're not even doing that. Take a look at the statistics of how many positions we have as per, and this is data as per the government itself, and how many of them are actually filled or vacant. Gives you an idea. Panelists who are joining us this evening: Siddharth Luthra, former Additional Solicitor General; Kailash Vastev, Senior Advocate with the Supreme Court; Deshratha Nigam, Lawyer with the Supreme Court, joining me. First up, though, I'll go across to Justice B.A. Khan, former Chief Justice of Jammu and Kashmir High Court. Justice Khan, thank you so much for joining us. What is your view on this problem? Have we for our own faults, aggravated the problem of delayed justice and allowed it to fester in such a manner?
Ma'am, let me first establish my credentials. I have been a part of the process of appointments in 3 high courts. And according to my experience, the scenario which we witness today and the exasperation which you are showing, the Supreme Court is showing, or you are mentioning, according to me and to my mind, this is a situation arising out of a conflict of interest between judiciary and the executive. And this conflict of interest has been there for ages. And it has aggravated more recently when Article 124 and 217 were interpreted by the Honorable Supreme Court in Advocates on Record 2 cases, in a way usurping the power of appointment to themselves, to the collegium which has been created. And this article, if you have a look at it, it says President will appoint in consultation with any number of judges of the Supreme Court and the High Court. And that provision was interpreted to mean that President will appoint in consultation with the Chief Justice of India and his first, they said, 2 colleagues. Then they said that may make it more broad-based with five first senior colleagues. Now, what happens is that the delay is firstly on the part of the judiciary, may I tell you, because there is no consensus in a high court collegium first. Let us talk about the high court judges first. They take months on, and they have likes and dislikes, and they have their own interests. They want to push up their own people. And it happens everywhere. And assume that situation is come over and a consensus is reached at the High Court, then it goes to the governor. That means the state government. The state government has his own interest in it. The chief minister and the governor has his own finger in the pie. They also want to approve if the man is pliable, if he is their man. If he is not their man, then they will hold it up. Ultimately, even if it goes through, it goes to the central government. Now, central government takes its own time by ordering investigating agencies to do this and to do that, and most of the time investigating agencies reports have proved wrong. They have branded a teetotaler as a liquor addict. Now, leaving that apart, now that investigation takes months and months and months and months. Now, after that thing is over, then the matter goes to the Supreme Court Collegium. Then Supreme Court Collegium has again its own conflicts. The 5 judges or the 3 judges, if they are the collegium, they don't see eye to eye with each other. And they have their own likes and dislikes. And the collegium functioning has so much disappointed us that we have been raising our voice for the appointment of an impartial and independent Judicial Appointments Commission. Now, if you say, if the Honorable Supreme Court says exasperated with the executive's delay, they must look into their own delays first. Now, coming to the executive delay, may I tell you that the situation has aggravated, I was telling you, after the judgment of the Honorable Supreme Court, striking down the Judicial Appointments Commission. See, both sides have a tendency that we must be the scoring first, or upmanship. Now they say if we could not, I remember late Mr. Jaitley saying, okay, let them strike down, we have our own ways to deal with it.
Yes.
Now, what are those ways? Those ways are these ways.
Yes.
Sit on the recommendation of the Supreme Court. Delay it. Don't clear it. The letter, it gets frustrated. We have cases where recommendations of the Supreme Court are pending for more than 2 years, 3 years. And lately, Mr. Venugopal, Attorney General, said that we will clear our recommendation in 6 months. Where is that person? Now, all this happens, one would believe that this exasperation, if it was in good old times, would be taken seriously, and the executive of the day would mend its days, but that is not so. We see an institutional erosion. no executive is respecting the Supreme Court work today.
Yep.
I remember a time when an observation was made by the then Chief Justice of India, Justice Anand, against Mr. Ram Jethmalani. And can you believe that he was summoned from a tour from Pune and was made to resign? Now, today, can you have such a situation that if you have so many observations for the day, for example, this observation,
Yes.
But who cares for it? Nobody cares for it.
Increasingly, we're discovering that, Justice Khan, that even when it comes to Supreme Court, not just observations. Just before this conversation, we had one about, our politicians and the Supreme Court asking them to be clean and to widely publish information about their criminal cases, and the parties failed to do so, and 8 of them got penalized today. So not just observations go, without being reacted to, sometimes even orders do. But I get the point, thank you actually so much for putting this in perspective.
Give me a minute. For
yes,
example, there
yes,
is already
sir.
a Supreme Court order is already there, fixing timelines.
Yes.
I was a part of the Chief Justice's conference, which fixed a timeline. That was way back in 2007. Then we had, again, for example, this order of the Supreme Court in 2019, and I remember that Coldfields case, which fixed a timeline that you will have 4 to 6 weeks for CBI inquiry and sending back the recommendation to the Supreme Court. And Supreme Court will have this much time to forward it to the central government. And after Supreme Court forwards the recommendation, they will have 6 weeks to clear it. And in case they have reservation, they will send it back. Then they will have again, if it is reiterated, then they will have again 6 weeks to deal with it and to clear it. Second, but who cares? Who bothers? Those Chief Justices' conference resolutions are gathering dust somewhere. So are the Supreme Court orders fixing timelines.
Right.
But no timeline will work unless the judiciary itself deals with the situation. And there is some sincerity of purpose. I thought the purpose was to select the best. That is not happening. It is select your own favorites. Both sides want that. So delays happen. What do you do about this?
Well, Justice Khan, thank you so much for being this candid about, what the true picture is and where it stems from. Siddharth Luthra, to you next, since the conversation has reached this point already, where, we must acknowledge that the delays happen perhaps from both ends. Yes, the Supreme Court 6 times in this year has asked the government about what's happening. But at the end of the day, it's the common man who will suffer when we don't have enough judges.
You're absolutely right. We are faced with a situation where justice cannot be dispensed effectively across the board with reduced efficiency to almost 50% in some courts or even more. So the issue is really this, and this is a matter of some concern. And to take the point forward from what Justice Khan said, Chief Justice Khan said, if you are going to take 2 years, irrespective of where the delays lie, if you're going to take 1.5 to 2 years to decide whether to appoint an individual as a judge or not, how many people are going to be willing to come forward? There will be 2 kinds of categories of people who are keen to join at the High Court level. The first category is going to be a person who would like to join, hopefully, depending on their capability, at the age of 45, 46, so that they have a shot at being a Chief Justice of a High Court and perhaps reaching the Supreme Court and maybe even being CJI. The second category are people who are willing to join later. And then you have the promoting judges who come in from the magisterial service or the session judges. By the time you appoint them, they have 2 or 3 years left because your processes just go on and on. And this is reaching a level where you will have a lot of very talented people who do not want to be lingering for 2 years. And there are enough instances where people have actually, their consents have been taken, they've been asked, and then they've decided to drop out because they believe that, their desire to join at a certain point is no longer relevant 2 years, 1.5 years later, because people move on in their lives, they get busy with their work picks up, professionally they believe more committed, and suddenly they feel that, we've given up 2 years of our life, we don't know which way this is going to go. So there is a serious need to address the delay system. because that is how you will get good talent. Otherwise, you will suffer a talent deficit. Where is the fault lying? There are definitely delays at the Collegium, undoubtedly. And I concur with Justice Khan. There are delays there. The process of inquiry is at one level. The secret process is also very personalized. So, you are making inquiries from personalized contacts and therefore your inputs about individuals may not be accurate. The problem also is at the government level. You have applications which linger endlessly and matters lists go up to the government, then they come back, and 1.5, 2 years later, 6 months later, how are you going to justify that? Eventually, what the funny part is and what the real, should I say, irony is. Who is the greatest litigant in this country? The biggest litigant is the government.
Right.
There is no greater litigant. So now there are two ways to look at it. Is it that governments of the day want to take decisions which they do not want adjudicated? Or do they realize the cost to the taxpayer by endless litigation? Because despite the new litigation policy, which came in about 10 years ago to try and reduce litigation is not ebbed. It is not ebbed, it's just gone on. So you have government litigating from, the smallest thing, from a disability pension to a large constitutional issue. And while these matters are not determined, there is a great, especially at the Supreme Court level, because of paucity of judges, there is a great spiraling effect, because when a matter is pending in the Supreme Court, the High Courts also have to wait till an adjudication happens from the Supreme Court. As a result, you are causing consequent delays from the top till the bottom.
Right, absolutely.
And these have to be calculated, not just in terms of an individual case, but the loss to the nation, the loss to the citizen, and the loss to access to justice.
Right.
So these are three parameters. And I think it's time, whether it's government and the Collegium, they really have to sit together and find a common ground, because we cannot continue with a situation where our justice delivery system is getting handicapped. I'm not going to say why or how this is happening, because that's for the parties concerned to see. But we need a solution, and we need the solution now. It can't go on.
Mr. Kailash Vasudev, when it comes to the High Courts, total sanctioned positions 1,098, total working strength 643, 455 vacant spots. Telangana High Court has 69% vacancy. Patna High Court has 64% vacancy. 64% vacancy in the Patna High Court. Do you think, taking up again from the point that Justice Khan made, that maybe we need to go back and look at another alternative as to how these appointments are done? The big disagreement that took place on the National Judicial Appointment Commission and the Supreme Court verdict in 2015, do we look at that as an option again, or something else, if that has become a sore point between the two sides?
Good evening. We are entering into the thicket of a democracy where we are destroying each other. It's a terrible destruction in a system of the judicial principles and the judiciary on one side. I beg
ask him why.
I beg pardon, sir?
I offered you judgeship and you refused. Yeah?
I refused because of delays. Please understand, at that point of time when you asked me, if you recall, the delays were running into 2 years.
Yeah.
And
we couldn't afford to wait for 2 years. Sir. I'll come back to that.
May I just say what a loss to the country and the system, Mr. Kailash Vasudev,
I was
because of the same delays.
I was responding to Siddharth that the best people do not come.
Yeah.
And are
No,
you
sir.
one of those because of this?
I'll come back to your answer. I'll answer you in a minute, sir. Today we have a situation where you have 22 judges for a crore of people, for 10 lakh of people. So the judge population ratio is absolutely terrible. Now you have vacancy positions where the judiciary is functioning on a 50% capacity. Let us look at it differently. Each judge has a term which everybody knows is going to retire on date X. If you know the date of appointment, I do not know why the Collegium holds its hands back. You should nominate the persons before the date of retirement. The consequence of the whole situation is because of delays in the Collegium, for whatever reasons it is, good, bad, indifferent, leads to a situation of a conflict. The government is not willing to appoint people easily nominated by the Collegium because they have their own interests. Please look at the present situation. After the NJAC was struck down, how the judiciary has been tinkered with, I use the word tinkered with, in the matter of appointments. The Finance Act is used as a money bill for the purposes of regulating appointments to tribunals. The amendments take place to the finance bills of 2015-16 have been amended further in the recent times, where sections 184, 185, 186 have been totally substituted. So the intention on the part of the government is they want to retain absolute control on the appointment of judicial officers to the subordinate judiciary, and they do not make appointments to the higher judiciary, that is the High Court and Supreme Court. Supreme Court today has got 6 vacancies. We will have a large number by the end of the year. The situation emanating is total chaos, total lack of faith between the judiciary and the government. The third limb of the system, which says that the judiciary will be left independent to work on its own, is no longer true. The observations by the court in recent times, please make the appointments. We are sending you names. Why are you rejecting it? This is very simple. We don't want to appoint. We're going to keep everybody in abeyance because there is no statutory provision or accepted convention under which we have to appoint. This only happened at one point of time when in 2010, 11, 12, when Justice Kapadia and all put their foot down saying either you appoint or you see the consequences. So the government then said that, all right, we will appoint. Names were returned and they went back. So if you look at that situation, till we in the judicial system don't stand up, we are going to be standing down in front of our people. Come to the second situation. Your judge population ratio has to change. To bring about that change, nobody is willing because when the litigation is 70% against government and there are a lot of sensitive matters pending. Let's look at it this way. Khan Sahib, you have been a Chief Justice. You've seen the CBI proceeding in political matters. They don't proceed. Those cases stay pending for years together, decades. Mr. Luthra is here, he is here. Mr. Nigam is here. They're also aware as to how much time prosecutions take. So therefore, what we need today is a radical overhaul of the system. Let the judges put their heads together, prevail upon the government, and let the government realize that without the judiciary, this country is not going to make any progress as far as independence is concerned. We have sacrificed independence. We have sacrificed our rights to the people. And the people are now realizing that this is all becoming a situation where the faith has ebbed away. It's a system which needs to be reconsidered, reconstructed, and redeveloped. They did this in England in 2006. The Royal Commission came. The House of Lords was abolished. Today, vacancies in England are filled the day they fall vacant. There is no delay in filling them because there's a permanent commission which assists the judiciary in doing it. The president of the Supreme Court, the erstwhile Lord of House of Lords, is there with information as to who's to be appointed when a vacancy falls. Why can't we have it here? What stops us accepting bickering between the systems? That has to stop.
That has to stop and come up with a system that works for everybody and, gets the wheels of justice rolling. Mr. Deshratan Nigam, can the Collegium, the senior-most judges of the Supreme Court of this country, actually come up with a system and prevail upon the government?
Tanvi, let me be very, very candid out here. Mr. Kailash Vasudev not being appointed is certainly a loss to judiciary. And I hope the government is very clear in mind so far as Siddharth Luthra is concerned for Supreme Court. And I'm very clear on those issues. And I know these two gentlemen personally, and I've appeared before Justice Khan a number of times and have been on debates with him on various news channels. And he was quite candid. And let me tell you, I have not come across anything in the English language where consultation can become concurrence. I have researched a lot, and it has never been all over the world. All over the world, the democracies, the elected representatives are responsible and accountable to people. They appoint judges and they are accountable to people. If they make a bad choice, they can be punished by the people in the next election. Now here, if you look at the 1981 first judge's case, then 1993 second judge's case, and 1998 third judge's case, it started from 1981. The primacy of CGI's opinion was given for recommendation, whereas earlier it was consultation only, mere consultation. Then the next second judge's case made consultation as concurrence. I mean, abrogating all the powers which the Constitution gave to the elected representatives, and the elected representatives and the elected government merely became a post office. That was never the intention of the makers of this Constitution. This is the biggest mistake that has been done by the judiciary, and this collegium system has to go lock, stock, and barrel. I'm very clear on it. And the entire delay, the collegium system is so opaque, it's completely non-transparent. There is so much of a scope of nepotism out there, and so much of controversies in appointment of judges. Prior to 1981, if you leave aside the emergency period, the appointments were going on very, very smooth. So this system where the judges should not appoint themselves. It has to be in the domain of people who are accountable to people. President of the United States appoint, it goes to the Senate approval for Senate committee. And then after that approval it does. And then even if they don't agree, then the final lies with the veto power of the President of the United States. So people who are accountable to the people of this country, that is what the will of democracy is. And they must appoint. And since they are accountable to people. And therefore, this system has created a lot of problems. And as I said, I don't want to name judges out here. And today, if you read the judgments, and everybody on this panel would agree, the quality of judgments that are coming out, so much so-and-so said this, so-and-so said this. In our considered opinion, this is the judgment. Complete lack of analysis and logic in the judgment. I'm telling you, I fail to see logic in judgments except very few judges. And you can see the quality of judges from their judgment. And I'm very, very clear that some system where the parliament takes control, the people of this country take control of the appointment of judges, then only the system will be corrected. All the delays would go.
Okay.
Would go. And if there are delays, at least we can catch those, elected representatives in the next election. Here you are wrong. And therefore, we are not going to vote for you.
Well,
the people
to a great extent, Mr. Nigam, I do agree with what you're saying. Conceptually, I'm not too sure if this US system is something that we need to look towards at all. While they're very open about their views and political leanings, but that's how even the appointments go. And I don't think for a democracy that works well either. Mr. Luthra, I know you want to make a point, but let me just quickly bring in Vikas Singh also, with us. Mr. Vikas Singh, what started off as a conversation basis what the Supreme Court has said, and we've actually brought up 6 instances where the Supreme Court questioned the government as to why they were not clearing the appointments and adding to the problem of, vacancy in the judiciary. This conversation has very quickly turned on its head and become a conversation about why maybe we need to relook at the collegium system, the way it's happening, and a part of the responsibility also lies with the judiciary, not just the government.
Well, according to me, 80% of the problem today is with the judiciary as far as filling up vacancies is concerned. Although I agree that the collegium system is the right system in our country, but the way the collegium has functioned or the way the system has functioned, it is really, really something which is not acceptable at all. I mean, it's very opaque. I was president of the Supreme Court bar in 18 and I'm president of the bar again. And to get Supreme Court lawyers to be considered by a collegium is a challenge for me. They are not ready to consider our names. I'm not saying that to appoint them, to appoint the best, but to at least consider my name. And when I take it up with the Chief Justice of India, the approach is that let it be done in a hushed manner. I don't want to, ruffle too many feathers. So this can't be, something which should come as a matter of right is being, I have to really plead for that and really beg for that for our lawyers to consider as judges of the Supreme Court. Now, I'll tell you one thing, Tanvi. When the constitutional amendment was done, it was struck down by the Supreme Court, and now we are back to square one of the collegial system continuing. But there is a midway, and I had suggested that to Mr. Ravi Shankar Prasad, I have suggested that to Mr. Kiran Rijiju also, that there can be a bill to regulate the collegium system. Why doesn't the parliament do that? I mean, they may control, they may have the turf with them, but the parliament can definitely say that how will you do, what names to consider, you only decide. But what process you will follow, from where will the names come up, will the names be verified by somebody? You are at least forced to look into all the eligible names. Now that's not happening. Now today what is happening, there are 3 members in a collegium in the high courts. Now the 3 members literally distribute amongst themselves. One gets his juniors or his relative, the other gets his junior or his relative, or people known to him, or people who've been running after him, or people who come to their homes, and that way these lists are distributed amongst them. There is no way by which a good practicing lawyer, and I'll tell you, Tanvi, something very, very important. A good lawyer, today's system, the kind of salary that a judge gets, is not interested in becoming a judge. It is our responsibility as a system to request him to become a judge. Now, that if that happens, you will get the right people becoming judges in this country. Now, today, a good lawyer has a good practice. Why should he become a judge? So you have to actually cajole him. You have to request him. You have to say that, please give up your practice. You have to give back to the system. If you make that effort, you will get good people. But nobody is interested in doing that. And that is why I have a huge issue with the collegium system, the way it's functioning. And I really, really feel that something very drastic needs to be done. Otherwise, as Mr. Deshnidam Nigam very rightly pointed out, the quality of judgments are going down, the quality of judges is going down. And this way, the judiciary, which is going to be in our system, where we are claiming to get towards being a leader in the world. If our judicial system is not having the best talent and the best people, what faith will a foreign investor have in our country? I mean, the judiciary is the real cutting edge for a foreigner to know that there is a proper rule of law in place. And if I go to this country, I will be treated like, for instance, a lot of people don't go to Dubai because they feel that nobody can sue the king there, and most of the business is being done by the king.
Okay.
So that is a huge problem in India today.
Okay, a very, very difficult problem with many nuances, and perhaps the answers and the solution will also be equally difficult to come by. But Mr. Luther, do you disagree with what Deshratan Nigam was saying about how it's the current system which is reducing the quality of the judiciary itself?
So let's understand, some judgments definitely are not as crisp as they used to be, but then we've seen that over a period of years, whereas some judgments are outstanding. So that's one part. I just need to clarify on 3 things which I must point out. If you have judges who are doing 50, 70, 100 cases a day, quality is going to fall. There is no way quality is not going to fall. I mean, I spoke to a judge in Allahabad High Court yesterday. Well, yesterday he was there on Friday. He did 120 matters in 5.5, 6 hours. Now, quality is going to be impacted if you have that kind of numbers in a 6-hour working shift and you're working till late. So that's one issue. So we can't just blame it on the judges or the individuals. We also have to understand the numbers are enormous in our system, which affect quality. If you have judges like they do in the Western world doing, the Supreme Court of USA perhaps does a total of, it has 8,000 cases that come, they select 80 odd cases to do. And out of that also they may do 10 or 15, at one case at a time for over weeks and months. That's not how it works in India. In India, a judge is doing 50, 60 matters on a given day. And they're all human after all. That's one. Second issue, just to clarify one thing which my friend Deshratan Nigam said, the third judge's case was the legitimization of the collegium system, because that was a reference by the government at that time asking as to why should we not broad-base the selection of judges by having and to the nature of the collegium. So that was a reference answer. It was not decided in any case. It was an opinion the government asked for and they got it. And that's where the collegium was actually cemented and came into the being. Today, the point is, and while my friend Deshratan, and a very old friend, is right when he says that we may want to change the existing system from the collegium system, but the fact is the constitutional amendment was struck down. And it is important for the government of the day, whether they appreciate it or not, to realize that the collegium has been struck down. And therefore, as Vikas Singh said, to work out a system, or Justice Khan said, to work out a system which is operational. I'll just clarify one thing. When the 5 judges struck down the collegium, the MOP came up into being. And the MOP was under consideration by a bench headed by Justice Keir at the time. He was not then Chief Justice. And while examining that, initially they thought they'll iron out the MOP, the Memorandum of Procedure, which is the procedural aspects of appointing of judges. But after 2 days of soul searching and calling for requests from all over, the matter was referred back to the government. Now that is the handle that the government has, and the Memorandum of Procedure is being used now to delay applications. And that's what's causing delays at the end of the government, which is not to say there are not delays and recommendations being made. That's absolutely right. So what we really need to work at is, and I must tell you, there is a lot of legal talent available.
Right.
Pick it at the right time. We don't want to lose them like we lost Mr. Kailash Vasudev.
Right. Okay, if I can just go back to Justice Khan, Mr. Nigam, I'll come back to you in just a bit, but I want to go back to Justice Khan first. And Justice Khan, you mentioned a wide variety of reasons, and you know it's a fact that there will be local bar politics to nepotism, to other kinds of groupism activities, to even government interference or whatever. There could be several reasons for the push and pull at every level of this appointment process. That being said, can a government resort to, or should a government resort to these kind of arm twisting tactics, that if it's not going to be our way, if we're not going to clear the appointments?
Tanvi, I had mentioned at the very first stage that it's a clash of vested interests. Why should not government, as Mr. Nigam was saying, give this whole power to the elected representatives only? In some systems, you will have a verification done by the parliamentary committee. For example, just as we have Senate hearing in the America. But it's not in practical terms, it's a clash of interests. Executive wants their people to be in, and this collegium people want their people to be in. This is the practical I am telling you. The rest is all theory. Why are they holding it up? Because they know that after inquiry, the man is not going to be towing out this thing. And we have come to a stage where people want that they must be ideologically aligned to us. That is why the delay. And in case of judiciary, the delay is because there is clash of interest between the members of the collegium. One wants his own man, the other wants his own man. And there is no transparency. There is no criteria on which to select. What transparency is there? If you tell them, you give us the reason, with great effort, we have been able to get it on the website that this has been recommended and so on and so forth. And they say if we give the reason, the other man will be stigmatized. That's not so. Number two, Vikas was saying that the best system is, collegium is the best system, and there must be a regulation of its functioning. But to that, the answer is that there can't be a law which can regulate the functioning of a collegium. After all, there is a human element working on that. Number two, via media had been taken to have this memorandum procedure which Siddharth was mentioning. Now, can you please now look at the joint connivance? This memorandum of procedure has not been approved or cleared for the last how many days after the judgment of the Supreme Court in the Judicial Appointment Commission case?
Nor has there been any participation.
If that has not been cleared, and if there is a joint connivance, and if they are shifting the buck from one to other, judiciary, the Supreme Court says, government, you approve this, and government says, no, you approve this, and both are willing to put it under a curtain, then how do you how do you regulate it? Now, the only solution for any right-minded well-wisher of the judiciary and the executive is that you must have an independent and impartial Judicial Appointments Commission. And this is not asking for a moon. This is something which you can do. This is something which you can borrow from South Africa. This is something which you can borrow from UK, as Mr. Nigam was mentioning just now. They reformed their whole system in 2005 when they abolished the Privy Council. And they constituted a broad-based commission in which all sections of the society have representation. And their advertisements are invited, in which everybody can apply for consideration. For example, academic people can also, belonging to some professional people can, chartered accountant can also apply. Can you believe we don't have people in the high courts, judges who can deal with a tax matter? We have a crisis in Supreme Court, they can't deal with a criminal matter. There is not a specialized criminal bench in the Supreme Court as Siddharth would know. This is the situation. What I'm saying is that a balance has to be struck, and that balance has to be that if you are convinced that you want your judiciary to be independent, if you are right-minded, and if you want that people should come on merit and the meritorious should come up, if you are wanting that this system should work efficiently and people should be satisfied and some justice should be given to them, then please shed your conflict of interest and evolve a system in which there is a balance. Balance would be broad-based. A judicial commission constituted last time, which was struck down. It was not a balance. It was not a balance. It was again 3 judges of the Supreme Court. Okay, then 3 people from this the executive, in which the argument, spacious argument on which it was struck down was that law minister being a member of this thing is a threat to the independence of judiciary. What is that? Well, law minister is now not clearing your files. Then you are crying horse, exasperation. Same law minister, if he was a member that time, then how did he constitute a threat to the, because he is an essential key man in the appointment process. So my suggestion always has been today is that kindly make an effort to have an independent, impartial commission.
Okay.
And as much free from influence from the executive as from the judiciary.
Okay. Fair enough. So, in fact, Justice Khan, you actually took me to the point that I was going to raise next. What is it, Mr. Kailash Vaste, for a lot of our viewers who may not have tracked or understood at that point, the reason why Supreme Court struck down the NJAC when they said it's an ugly compromise between politics and the government and what judiciary should be? And is there a way out from there, like Justice Khan was saying, change the mix of people who would have the deciding power?
I go one step further. Khan Saab is right saying that we must have a radical change. To begin with, what we should do is that within the judicial system, using all the Chief Justices of the High Courts and the Chief Justice of India, put up an absolutely independent commission within the judiciary. Let them investigate, let them get names, let them recommend, so they have a pool of officers, a pool of lawyers available for the purposes of appointment as judges. If you have a permanent internal commission where you have been able to get names and garner people who are willing and offered their services to become judges, I think that will work even better, because within the judiciary, you will be able to ascertain people and you must involve members of the bar in making these recommendations. We at the bar know more about our colleagues and a little more about the judges at times than anybody else knows. We often say, if a matter goes before Judge X, we're going to get into trouble. If it goes before Y, he is a more liberal man. On the criminal jurisdiction, Khan Saab is there. He knows more about what's to happen in his court than we do. So you see, the independence of the judiciary will come by the judiciary acting in the larger interest of everybody. Please understand, we're in a democracy. We are not functioning in the democracy as a democracy for the leaders, for the government, by the people. We are working in the judiciary as a stalwart which looks after and prevents an abuse of authority. That is the function essentially of the judiciary. Most importantly, the government must realize that 70% of the litigation in the courts is attributed to it. You have the recent press, today's press, no retrospective amendment to tax laws. They have now realized how the economy suffers when you make these kind of laws which are draconian in their effect. These were tried by the earlier governments, it was struck down. But today, if the parliament is realizing that it needs to rectify its position, then let parliament realize that norms should be laid down where proceedings in court can be controlled by the government, that is appellate proceedings. We have land acquisitions. We have so many matters where government comes in frivolous cases. And interestingly, it is in these frivolous cases that we spend more time in the drivel than in laying down the law. Till you don't change an attitude by the government towards litigation, change the litigation policy, make sure that the courts are available to the average man on the street for his daily needs, you will not have a system which can work. And with the present strength of judges, 22 to 10 lakhs, this system is not going to work. Do what you want. Third, in the selection of judges, and here, Khan Sahib, I have a bone to pick. We have judges and families which are there for 3 generations wanting to appoint the 4th. Why?
That
Judiciary.
I have already highlighted in my pieces which I have written.
That's right.
Justice.
So therefore, if you're going to appoint judges as a hierarchy within the family, the attitude is very simple. You are not looking at the system, you're looking at the family. You're a politician looking at the family. You are a person looking at your own positions without wanting to give up the beautiful farmhouses in which you stay in Lutyens, Delhi, 3 acres, paradise with all facilities for generations together. I don't know, Mr. Nigam might have a different view on this.
Mr. Nigam, in fact, Mr. Nigam, even the bench that gave that verdict striking down NJAC, one of those judges himself, Justice Kurian Joseph, now says he regrets. He was quoted, and this was widely reported at that time, that he regrets having that view and giving that decision. And I actually increasingly find more and more people who at that point were more supportive of the Collegium than the NJC, saying, okay, we need to re-look at this. Whose onus will it be to restart the conversation? Should it not be the government?
Please give me 30 seconds.
Yes, 30 seconds, Mr. Nigam,
before you go. 30 seconds. You see, I didn't want to take names about judges resiling from their positions in judgments. It has now become fashionable. We had 4 judges who came forward to criticize the system.
Yes.
They said nothing effectively. At the end of the day, they all said they made mistakes in having a press conference. Pray, may I ask you, why did you do it?
Right.
If you didn't have anything to offer, any alternate to work out, then why did you denigrate the system in the manner in which you did? If you had something positive to offer, if you had the guts to resign, I could understand. But staying there, continuing, and then repenting, and then joining the Rajya Sabha is something which is in very bad taste. That is not the judiciary.
Okay, so yes, final comments from Mr. Nigam.
Tanvi, I think everybody had secondly, put their viewpoint. And, there is a theory of checks and balances in democracy and accountability. And that requires the control of the entire process with the elected representatives. And judiciary is neither supreme nor above the law. That's the prime tenet. And to think that judiciary is supreme and they can appoint themselves, they can strike down any laws that they want, I certainly don't agree out there. NJAC was a good beginning, kind of a balancing step. However, there were some mistakes done by the then Attorney General. I'm very clear about it when the suggestions were made in court. And they could have been considered and they could have gone back to the government and taken some kind of instruction. But it got stuck up in court and ultimately it was struck down. And we do require a system, a thorough overhaul of the system so that the elected representatives, and I'm reiterating again, are not merely post offices. They are not, people don't elect them to be, passing name from here to the president. That's not the intention of the constitution makers. That is why clearly the word consultation was used so that the elected representatives remain answerable to the people. And that situation has been changed. And that should never happen in a democracy.
Well, Mr. Luthra, I know you want to make a point, but my apologies have already gone over. And I think my PCR team is going to then penalize me if I stretch this any bit longer. I have one more conversation, but I do promise you it's been an enlightening conversation. Maybe more of these conversations can take place, because I do agree with all of you on one aspect, that we definitely need to look at the current system to find a solution. My view is simpler than the experts and the top legal minds who are with me on this conversation, is just this. We cannot have a situation where over 40% of your existing pending cases have been going on for over 5 years. 40% and more of our cases today have actually gone on for over 5 years. In fact, 16% of the cases, 16.87% of the cases have gone on for 10 to 20 years in our country. One of the panelists was just telling you about how one single judge was presiding over 100 cases in a matter of few hours. What is the quality we are going to expect from them? And if it takes us 5 years, 10 years to give a verdict, what is the justice that people are waiting for? Why should we, the common man, seeking justice, turning towards our judiciary to right the wrong that has happened, why should we have to wait for so long? Why should we have to run around just because these two sides, the judiciary and the government, the executive, cannot agree on what's the right way to appoint judges in our country? And so, over 450 posts in high courts are lying vacant. Imagine the kind of efficiency that would have come into our system had we only filled up these posts. I'm not even talking about any other kind of boosting the judiciary or strengthening it. Just imagine if the basics are done. One can only hope that we find a way out rather than just these back and forth, push and pull that seems to be going on between these two arms of our democracy. Thank you for joining us.